Hi, everyone. Thanks for coming. Welcome to our panel on courts under the next president. This event is co-sponsored by the Program in Public Law and by the American Constitutional Society, which, for those of you who aren't familiar with it, is a national network of law students, law professors, judges, attorneys, activists, who all share a progressive vision of the Constitution and are working toward ensuring things like individual rights, equality, democracy, rule of law, and so on. So given those priors, and given that this panel was organized, I think more than a month ago, maybe 2 months ago, I think it's safe to say that everyone involved in organizing the panel was expecting that our conversation might look a little bit different than how it will look. We were going to talk about, what sorts of impacts appointments by President Clinton might make on the federal courts, including the Supreme Court, shifting it more to the left than it has been for years and years and years, and wrestle with difficult questions about the legality and propriety of the Republican senator's blockade of Judge Garland and of threats by some, including our own Senator Burr, to keep Justice Scalia's seat open during the entirety of a Clinton presidency. Now things are looking different. We're looking ahead to a Trump presidency instead of a Clinton presidency, but many of the same questions remain relevant, although with a somewhat different valence now. As Senate Democrats and as students and academics who want to study questions of separation of powers, think through what sorts of responses are possible by Senate Democrats to likely Trump nominees and what sorts of responses are normatively appropriate. So we have 4 terrific panelists to help us think through these questions. Professor Michael Gerhardt comes to us from UNC, where he is the Samuel Ashe Professor in Constitutional Law and the Director of the Program in Law and Government. Professor Gerhardt has extensive experience not just in academia, but also in government, including participating in the confirmation hearings of 5 of the current Supreme Court justices. Professor Craig Green comes to us from Temple University. He has written a great deal about courts and judging, including debates over so-called judicial activism. And he also clerked for Judge Garland on the D.C. Circuit, and so he brings a personal perspective to the issues surrounding Judge Garland's nomination. Next up is our own Neil Siegel, who needs no introduction, although I will give him one anyway. Neil is the David W. Eichel Professor of Law here at Duke. He's also a professor of political science. He also co-directs the Program in Public Law and directs Duke's D.C. Summer Institute on Law and Policy. Neil also has experience with confirmation hearings. He served as special counsel to then Senator Biden during the confirmation hearings for both Chief Justice Roberts and Justice Alito. He writes about all aspects of constitutional law, but most recently, and I think most relevantly for today's topic, he has written on the constitutional norms and conventions that shape the relationship between the political branches and the federal courts. And last but not least, Georg Vanberg comes to us from across the street. He's the chair of the political science department here at Duke. And he has written a great deal on courts and judicial decision-making, and so we'll be able to, among other things, tell us a little bit about how political scientists think about these issues and how that perspective might be different from the perspective that we can get just within the 4 walls of this law school. Okay, so we've agreed that we're going to spend most of our time today just in conversation with our panelists responding to questions that I, and I hope you, ask them. But we thought it would help to start by situating our current situation in history. And Professor Gerhardt has generously agreed to kick things off with some sort of background and framing. So with no further ado, Professor Gerhardt, take it away.
I don't know, feels like a classroom, and gives me a little exercise. I can pretend like I had a little exercise this week. I'm still in probably a similar frame of mind as many of you, and I will tell you, as I look out and see your expressions, they look familiar to me. I spoke to a large group of students on Monday at the University of North Carolina, Chapel Hill. In spite of whatever differences these institutions have, it seemed very similar. It felt similar. I was at the University of Pennsylvania Law School yesterday, where I teach a class, and my class is still in therapy. And so, more importantly, they too are trying to sort of get their heads around much of what has happened. And of course, for us, part of the concern has to do with how whatever has happened affects and influences the courts now and in the future. What I would like to do in my remaining time is to give you a historical overview, give you a sense of some of the historical patterns that might help frame, to some extent, our discussion today. And to some extent, you may find a little bit of this surprising, but it's meant to put, again, in perspective the kind of debates, the kinds of issues we're going to be focusing on today. As you may know, this is now the 5th presidential election in which the winner of the popular vote lost the Electoral College. What you may not know is that all 5 of the people who lost have one thing in common. They were all Democrats. I'm not suggesting a conspiracy of any kind, but it's an interesting pattern to some extent to contemplate and what it may say about the party. As we zero in on this particular subject, this is actually the 7th time in American history in which a president comes into office with a pending Supreme Court vacancy. So in that sense, this has happened before. The other presidents who were unable to fill seats, besides, of course, President Barack Obama, were John Quincy Adams, John Tyler, Millard Fillmore, James Buchanan, Andrew Johnson, and Lyndon Johnson. They have some things in common that would separate them from President Obama. He's the only 2-time elected president in that group. And of course, some of them weren't elected directly themselves. Fillmore came into office because of the death of the president. So arguably, they are all presidents that typically are described as weak, politically weak. That would not have been the description one would have had of President Obama for much of his 2 terms in office. But he now occupies an odd place because it does look as if he will not be able to fill that final vacancy. Another thing I'll tell you before we get into the minutia of judicial nominations has to do with the last time a Democrat won a presidential election to follow a 2-term Democratic president. The answer is Martin Van Buren. Now, I think all of you know who Martin Van Buren was, which, by the way, distinguishes you from most people. But just to situate that, that's another factor that comes into play. I'm not saying the electorate was aware of this and had, I'm not saying, I'm not a believer in historical determinism and then somehow this was inevitable. But I think to some extent what you're seeing in this election is that Hillary Clinton was going upstream against a lot more than what we might even imagine. To some extent, one of the most constant things in American history is change. And I think you are now experiencing that similar kind of change. And we ought to keep that in mind as we think about judicial nominations. So now as we zero in on that, I want to give you a sense of how the current controversies look within the Senate and for that matter, for the country. We are concerned not just with a pending Supreme Court vacancy, but with many, over 50 lower court nominations. President Obama, in spite of his election, in spite of his popularity, which seems to rise, may well break 100 at some point in the relatively near future, in spite of all that, has actually had a lower percentage of nominees to lower courts confirmed than other presidents in the post-World War II period. there's been a lot of delay and obstruction that has applied not just to the Supreme Court vacancy, but of course to lower court nominations as well. So we ought to keep all of them in mind. The obstruction isn't just focusing on the Supreme Court, that's part of a larger picture. And the larger picture is that judicial nominations and vacancies mean a great deal to Republicans. One other thing to note, which has been noted many, many times, is the last time there was a majority of justices on the Supreme Court who had been appointed by Democratic presidents. Last time there was a majority of Democratic appointed justices was 1969. Had President Obama been able to make this appointment, it would have been the first time in several decades. Now, that fact was incredibly well known. It was not a secret in Washington, D.C. But the ability to transform the court, to shift its center, so to speak, and the death of Justice Scalia gave Democrats a surprising ability to do that, is exactly what everybody was focused on. So whatever stakes everyone in this room thinks were in play with this nomination, everybody outside this room, everybody in Washington, all Republican senators understood that. Even when Mitch McConnell made his decision, which was thought to be an incredibly risky one, in February, saying there shall not be this president shall not make this appointment. That was a risky strategy. We haven't seen that kind of expression of this kind of opposition before. We've seen opposition in different ways, but this long, this extensive, and here's one of the critical things, without hearings. All the other presidents that I mentioned had nominees that got hearings. Even Lyndon Johnson's 2 nominations that were made near the end of his presidency got more than 20 hearings before they eventually were obstructed on the Senate floor. This nomination never got a hearing, never got any process at all. That's very similar to all the dozens of other judicial nominations in play as well. 2 other things then to point out about the process real quickly. You can obstruct things in a couple different ways. I'm oversimplifying here. One is when you're in the minority, you can use different mechanisms, the most famous of which is called the filibuster. Filibuster is a function of Senate rules. And Senate rules, Democrats recently proved, among other things, can be changed by a majority vote in the Senate. So if there is a threatened filibuster of a Supreme Court nomination, the majority in the Senate has the power to change the understanding of the rules. And change the understanding of the rules to disallow a filibuster of a Supreme Court nomination. So everybody understands that if Democrats make that move, try and filibuster any kind of Supreme Court nomination, then in a sense, the next move goes to the majority party, which is, do they then eliminate the filibuster of Supreme Court nominations? And the answer will be almost certainly yes. We can predict the outcome of that particular scenario. The other kind of obstruction which happens besides one attempted by a minority arises with the majority. And that's a different kind of obstruction because the majority party gets to determine a lot of different things within the Senate, including what happens on the Senate floor, including whether anything happens on the Senate floor. That seems to fall within the scope of the discretion that Senate leaders have. So as we move now more to focus on this particular nomination and all its significance for the future of constitutional law, we should understand something, of course, Neil's been writing about and we're about to talk about, and that's the extent to which political leaders get to shape courts, and the extent to which the extent to which courts themselves are really political constructs. You're going to get to see that quite graphically in the next several months ahead.
Thanks, Professor Gerhardt. So let me start with a question that Professor Gerhardt has already spoken to, and I'm curious whether the rest of the panelists have the same view of it, and that has to do with the future of the filibuster. So we can talk about this generally, but let's start by talking about it specifically in the context of Supreme Court nominees. Do you all agree that if the Democrats use the filibuster to block a Supreme Court nominee, that it is a sure thing that the Republicans would get rid of it?
So I have to say, I think my faith and confidence in my ability to predict political results has taken a little bit of a downtick just in recent times. But I think what I would say is that it's very clear to everybody here, and I think on the panel, why they would, and so why the filibuster would be killed. It's a very straightforward set of thoughts about that's what we want, that's the obstacle, we can take out the obstacle, so we'll get what we want. And right now, I guess that feels like the much more plausible account of how things would go, but it doesn't always go that way, is what I would say. So the last big fight about filibusters was, about a decade ago or so, and there were compromises struck, and maybe there would be here too, and maybe it depends on who the nominee is, and maybe it depends on how long the protests go on, and maybe it depends on a lot of things, which is only to say it depends on a lot of things. But I think it's much more straightforward to imagine that, yes, Republicans, to a large extent, including senators, campaigned on their ability to change the composition of the court and save Scalia for Scalia at the risk of saying, make Scalia great again. And so when they have the opportunity to do that and confront a possible political challenge, I think it's relatively straightforward to think that they would. And the compromises and circumstances that would produce those compromises that would preserve a filibuster in some sense of Senate tradition that isn't actually even very popular among sort of the general public, but does have a long tradition. I think it's hard to see exactly how that would come to be, although I don't want to, a 15% chance, I think. No, wait, is that, something like that? You want to talk to this?
Sure. I mean, I think basically I agree, right, with that. I do think there is a countervailing consideration for at least some Republicans, right, which is that I think this strategy depends on the extent to which you could separate, and they might be able to do it, but to the extent to which you can separate abolishing the filibuster for Supreme Court nominations from the filibuster generally, because I think within the Republican Party, there are a number of people now who are in a tough position, right? They may not want to go along with everything that certain factions of the Republican Party have on their agenda, and so having in your back pocket the ability to blame the minority party for policy failures is very good cover for them. And so I think there are a number of senators who would prefer to preserve the filibuster, right, for that reason. So think about repeal of Obamacare, for example. If you can say, look, we've had to compromise on this, we've had to sort of come up with a revision of it rather than an outright repeal because we've got to get past the filibuster, that's something that I think many of them would want. And so I think this really depends on the ability to do it in the one case, but not then also be under pressure to abolish it, overall.
So like Professor Green, I am trying to the extent I can to get out of the prediction business. I think it's important to underscore just how historically extraordinary what Senate Republicans did to Chief Judge Garland. The closest historical analogy that I can come up with is what Senate Republicans did to President Andrew Johnson, who succeeded President Lincoln after his assassination. And this Senate not only refused to consider a Johnson nominee for the court, they reduced the composition of the court by statute to prevent him from making nominations. They then impeached Johnson on political grounds and stripped the appellate jurisdiction of the Supreme Court for the only time in American history. That's the closest analogy I can think of to anything like this. Senator Cruz can talk about 80 years of precedent, and it almost sounds like a legal argument because he used the word precedent. It turns out that it was 84 years ago that we last had a vacancy during an election year. I mean, we have 225 years of precedent of not considering anyone named Garland, right? I mean, that's about the same kind of argument. And so it's an historically extraordinary thing to do. Longstanding norms, conventions of political conduct that guide political officials in the exercise of their discretion, that try and contain partisanship within reasonable bounds, that all went out the door, I think, for reasons that Professor Gerhardt talked about, which is everyone understood the stakes. You're talking about the potential end of a judicial era, the loss of Republican control over the court for the first time in nearly half a century. So that leads me to think that the filibuster will remain as long as the Democrats don't invoke it. But I think part of the meaning of what the response to Garland is that neither side, if they were in control, was going to be very well prepared to keep the filibuster for Supreme Court nominations, because I think they can separate it for legislation if they choose to do that. The only way I see it not happening is if you have enough Republican senators who aren't as happy as they expect to be by a Trump nomination, and they're demanding someone else, then they might be prepared to let a filibuster stand so that they don't get this nominee and they're not really responsible themselves fully for killing it. But I expect that we're going to see a nominee that Senate Republicans will be very pleased with. And at that point, I think the question for Democrats is going to be, how much of a fight do you put up when you know ultimately you're going to lose, given the fact that the Republican base cares a whole lot more about judges than the Democratic base. And I think that's been a long-standing problem that if the roles had been reversed, you could be sure that this vacancy, right, would have been a much bigger issue on the Republican side.
Well, so let's talk about this from the perspective of Senate Democrats, in part because it is clear that none of us can predict political results, and so we'll do what we're better at, which is making arguments about what they ought to be. So we can think about this in two ways. One is the way that the question that Professor Siegel just teed up, which is, in the reality that we actually have right now, how should Senate Democrats behave, either sort of from a strategic perspective or from a doing what's right perspective? How much of a fight should they put up to the nominees coming from Trump? But I'm also curious to hear the panelists' views on how you all think the Democrats should have behaved if they had succeeded in winning the Senate. So if Trump had won the presidency, but the Democrats had been able to take the Senate, they would then find themselves in the position of being able to engage in some of the tactics that they had just gotten done criticizing while President Obama was in office and they were a minority. And so I'm curious to hear from you all whether you think that it would be possible to mount a normative defense for the kind of blockade of Judge Garland that we saw if the presidential shoe were on a different foot, perhaps depending on who the nominee was, or whether that's just kind of out of bounds based on our longstanding history of not behaving that way.
Well, I think to begin with, let's talk about what might have happened in an alternative universe in which Democrats were in control. I think that likely there would be two things. The first is I do think, of course, you would have seen the Garland hearings unfold and probably a vote on Garland, which may or may not have had to surmount or move around a filibuster. We don't know what would have happened for sure there. Then we get to lower court nominations. And so with lower court nominations, I think there are a few other considerations to keep in mind. If you're the opposition party and you control the Senate at the time, let's say there's a Republican president, what's not going to happen is you're not going to just shut it all down. I mean, one of the dangerous things about the precedent that just has been created is it's now lying around like a loaded gun that some other party may get to use whenever there's about to be another election. And guess what? A nanosecond after Donald Trump takes the oath, there's going to be another election coming up. And my guess is, and might be a safe prediction, there's always another election coming up. And so if that's true, and George can just correct me if I'm wrong about the empirics here, but if that's true, then I think Democrats would be challenged to really have to confront when and whether to ever use that precedent and how they would go about doing it. I don't think they would shut down judicial nominations entirely. I think they would actually see, they would process them. I think there would be moments when they would have to decide what to do about those nominations, that is to say, approve them or not, but I don't think they would deny a hearing. There may be other ways to block nominations in the committee, especially if you've got the votes. So I think you would see hearings, but you might not see people getting out of the committee. There's under Senate rules, you only get to the Senate floor on a judicial nomination, other than one to the Supreme Court, if a majority of the Judiciary Committee approves it. If the Judiciary Committee as a majority disapproves a nomination, it doesn't go to the Senate floor. So there's a lot of power in committee, and you can have those hearings. So that would be my prediction.
What I really like about the hypothetical of imagine if the Democrats had won, I mean, aside from imagine the Democrats had won, that's a fun sentence, but aside from that, I think the thing that I really like about this event and that I think is so important about this conversation is sort of a hypothetical, which is another way of saying what you folks are trying to process and think through. What if you can imagine some law school exam, God help you, that would be like, what if you were a senator and you had confronted this thing, and what would be the separation of powers arguments? And the one thing that I want to add, even though it's not quite on point, is I think this is what a generation means, actually. So for you folks, you might have thought you were the Obama generation. I don't know, maybe you thought that, and maybe you were going to be like seeing this progressive court moving. Maybe you saw some same-sex marriage decisions, and you thought that was how it's going to be. And now, in some sense, I'm speculating, but maybe what you're grappling with is actually it turns out that's not exactly who your generation is. Your generation is going to be the generation that actually lives the transition from Obama to Trump. And the reason I identify in a remote way with that experience is because for older people of a certain age, we had experiences like that with Bush v. Gore. I clerked for Merrick Garland when Bush v. Gore was decided. And for us in that generation, that was a big moment to figure out what is it actually that's on the wall or off the wall. What are the right ways to behave in this really weird situation that nobody possibly could have expected? There were very fancy law professors saying things like, there will be no nominees from this illegitimate president for 4 years. Like, what are you talking about? Are you serious? Yes, I'm serious. Wait, am I serious about that too? Like, do I actually believe that sort of those wheels on the wagon should be taken off in protest of the perceived illegitimacy of what had gone before? Now, today is not Bush v. Gore. There's no Supreme Court, and it all sort of happened real fast. But both Neil and Michael it's wrong what happened to Merrick Garland, just in case you were wondering. And the more you study it and the more you look at it, the wronger it's going to look. And so people who are looking for blood justice or revenge or some sort of legitimation of some sort of negative, nasty behavior, that justification is on the books. And this precedent, if it's called a precedent, lying around like a loaded gun, of course, you guys remember where that quote comes from, the loaded gun? From Korematsu? Right, Korematsu Jackson. That loaded gun, which until like today I would have said is an unloaded gun, like nobody loads that gun. Is it a loaded gun? Maybe you could check the news. But anyway, like I think there's a question about whether you take that opportunity from a relatively political, partisan, vengeance, justice point of view, perfectly legitimate fairness, back and forth, or you're the one who tries to rise above it. You're the one who tries to behave in a way that's good for the country, whatever you can perceive that to be, and good for the institution, whatever you can perceive that to be. The only thing I can tell you for sure is Chief Judge Merrick Garland is the latter category. He's the latter category. And so, for example, we haven't talked about sort of recess appointments or whatever else, but he's a person throughout his whole career has valued the country and has valued the institutions more than he's valued anything about party or back and forth or get you back for the thing you did last week. And I think that raises the hardest question for a 51-vote Democratic majority. Would they be the ones who, as they said before the election, were the adults in the room and who believed that presidents got to choose and believed that 9 was a good number and who criticized the Republicans for making arguments they thought were disingenuous and hypocritical, as a lot they did last time? Or would the Democrats be like, actually, you know what, double hypocrisy. We were just kidding about what we were arguing, and we were also kidding about calling you hypocrites. We got 51 votes, eat it. That would be sort of one response or the other. And I think that that's a very, for me, I'm sorry to talk a lot about it, but I think for me that's a very live, vital, experiential question that who's not your generation matters more, but as I'm trying to process how indeed I should adapt to things that I've witnessed that I think are really outside of institutional norms and how that affects my thinking about going forward. What do I actually think about institutional norms? As opposed to what some people might call cynical political calculus. So I don't know. I think that's a good question. I predict that 51 votes will not be, but 2 years there will be. 2 years, North Carolina, I think, will have another Senate election. There are other states that will too, Maine and Colorado. It's possible in 2 years they'll be having a very important Merrick Garland seat. We could call it that. We could call it Scalia's seat. It's a very important seat. But you all know there are more important seats out there. There's another couple seats that could possibly come to be that'll be much more important than this one. And those will be questions that maybe 51 senators might confront.
The general structure of the question is whether you continue to cooperate in a prisoner's dilemma when the other side is just defected, and it's a repeated game. Do you maintain your fidelity to institutional norms and conventions when the other side has just kicked them over from your point of view? Because the filibuster becomes small potatoes compared to taking one president's nomination, one president's vacancy, and holding out until you can give it to the next one. And that's the question. I don't think it's simply about hypocrisy or blood justice or vengeance. It's about, we have certain principles. 9 is better than 8, right? And we would like to see these norms function. And in fact, the Democratic Senate confirmed Justice Thomas, even though the Senate Judiciary Committee voted him down. And the Democratic Senate confirmed Justice Kennedy very close to an election year after rejecting Judge Bork as an ideological extremist. And if you want to debate whether he's an extremist, I can explain to you why he was, given mainstream politics and constitutional thought at the time, right? We don't have examples of Republican Senates confirming Democratic nominees, correct me if I'm wrong, Michael, in recent decades. And so the question for Democrats, both in the alternative universe in which they control the Senate and in the current universe in which they're going to have to decide how much of a fight to put up, is what do you do? Do you simply say we're the grown-ups and we're going to just act as if these longstanding conventions have not been kicked over, in which case people who behave very badly are going to be rewarded fantastically for their bad behavior? Or do you at least shine as much of a light on it as you possibly can to mobilize your own voters to care that whoever this nominee is should have an asterisk next to his or her name every time this nominee is the 5th justice? That this was literally stolen from one president and given to another. And it's not hypocrisy, it's not unprincipled, it's that there have to be consequences for the kind of behavior we've seen, or else we're always going to be on the losing end of this. That you can't simply roll over, that you do everything in your power, from vigorously contesting, getting as much in the record about the bad behavior by the Republicans, about what this nominee actually believes, and doing everything you can to stop it, even if you know ultimately you're going to lose. Now, what makes it a hard question strategically is knowing you're ultimately going to lose. And do you want to expend your capital on this issue as opposed to other things? That's what I think makes it a hard question. I think it's a less hard question if you actually know you can win. Not because you're happy about it or proud of it, but because you keep acting like the adult and doing the right thing, and not coming up with conspiracy theories and talking about it being rigged and talking about a crisis and investigations and impeachment if the other side wins. Right? You're not doing any of that, right? But you're at least doing something, right, to defend yourself in the hope that it'll be less likely in the future.
Let me just maybe add a couple of things. I'm not sure I've got a whole lot to add to the what's already been said, but maybe 2 things that strike me as important. The first is that I think at the end of the day, right, I'm a political scientist, so thinking about the world in normative ways is less familiar to me. I guess I'm more cynical and hard-nosed, but I do think this, which is that the sort of informal norms that surround how our democracy functions are critical, right? In the sense that, as Neil just said, but sort of placing some boundaries on partisanship, on the way in which we exercise political power, some of which we do formally, obviously, through our constitutional structure, but it's supplemented through many of these informal norms. And I think by reducing the stakes of politics in that way, which is what both the formal and these informal norms do, is critical to the stability of our political system, to the broad acceptance of that system by citizens. And so things that begin to undermine that, I think, are really worrisome going forward. And I think that the way in which Neil just put it, I think is exactly right. This is a repeated game in which part of the acceptance of these kinds of limits depends on the fact that we think the other side is playing by those same rules, and we think there's actually going to be turnover in power. This is a competitive political system. And one of the things that worries me about, and not just the Garland episode, but the general kind of rise in polarization that we've seen over the last 20 years, and especially the last 10, is that it seems to me it begins to undermine some of the respect for these kinds of informal norms. And I think that's a really worrying trend, whether or not you're sitting on the Democratic side of this or the Republican side. And so I guess.
Okay, so last question for me, and then I want to open it up to all of you. How important is this seat? So I don't mean how important is the difference between a Trump nominee for the Scalia seat versus either an Obama or a Clinton nominee. So that question answers itself. What I mean is how important is the difference between a Trump nominee and Justice Scalia? Or put somewhat differently, what, if anything, are we likely to see changing? I mean, so here we're getting back into predictions, but what might change now about our law going forward, given what's likely to happen in the next year or so?
I mean, I would hazard two guesses. One is, so how important is this seat? I think it's more important to the Republicans than the Democrats for a few different reasons. One of which is that nobody expected Justice Scalia to be dying. It was not on the radar screen. It was not. When you saw speculation about what seats would open, his was not one of them. This still might conceivably be called the Kennedy Court. Still, if it is, we just spotted the seat, which is likely to be of greater interest to Democrats and everyone else. But the second, so substantively and doctrinally, it matters a little more to Republicans and Democrats. But here's the second thing, which I think is very important, and I think this is kind of it's a little bit of I'm thinking of it, a little bit of the backstory of some of what Neil was talking about. Generally speaking, judicial nominations mean a lot more to Republicans than they do to Democrats. So Democrats are more willing to deal on a variety of different things because their agenda is broader. And it includes many different things, of which judicial nominations is one. For Republicans, the number one issue, I'll tell you the number three issues, top three issues are judicial nominations. Judicial nominations and judicial nominations. They care about it more as a party, I think, and they care about it more in practice. So what you'll end up seeing is Democrats are probably, at least in my experience, more likely to broker deals than their Republican counterparts.
So I think the seat is really important in a way we've already talked about, which is what people make of the Garland treatment. I think that there's almost no floor to how nasty future nomination processes could become in light of how badly Chief Judge Garland was treated. And I think that's just a possibility. And so in that sense, if you change the nature of the nomination process, you change the nature of the number of nominees, the type of nominees who are put forward and who are confirmed, if you change on a semi-permanent basis, to generational basis, if you change the character of that, then you change the nature of the court and the law. Example, when Bork was shot down, the lesson that most of America took from that is that even a really credentialed judge can be shot down if he's outside the ideological mainstream. That was the Bork lesson, thought to be the Bork lesson, to which, just to be clear, Garland was the solution. So you pitch somebody in the middle who has gold star credentials and is totally centrist and this sort of thing. If that doesn't work, then you might as well be a political hack, since you're going to have to scrape up votes wherever you can find them to try to get, and that would be a terrible result from this seat. I think that seat would have generational consequences. You've heard me suggest that I hope it doesn't come to that. In terms of compared to Scalia, I think we never got to see how right-wing Scalia really was, which is to say that I think that in the presence of a 5-justice conservative majority that didn't have to lean on people like Sandra Day O'Connor and Anthony Kennedy, we never saw the bottom of that pool. And so whatever you think of a Trump nominee, I have a hard time drawing daylight between whatever Scalia would have done and whatever this nominee might do. I think in that sense, the seat is not that important. And then I think the only thing I'd want to say last of all is, of course, just to be very, very explicit about it, there are these people who are still on the list of people who might not make it through a Trump term. Did I say one Trump term? I meant 2 Trump terms. There will be a Senate election in 2 years. There will be a presidential election in 4. I'll see you guys then, which is another way of saying that anybody who thinks that these issues are important and that courts, at least for law students or otherwise, reserves a higher spot on the agenda. It was on the menu 2 weeks ago, and it'll be on the menu again almost certainly in 4 years' time. And if there's anyone in the room who believes that that should be a motivating, mobilizing issue, it's not up to us. It's not up to us that it be. And so in that sense, I think this seat is not that important compared to the seats to come, and I think the consequences of that thinking going forward are also very immediate and vital for people who think about it.
So yeah, Justice Ginsburg is 83, Justice Kennedy is 80, Justice Breyer is 78. There's a chance they'll all be on the court in 4 years. There's a chance they won't. If you want to just focus on how important this seat is, imagine they're still on the, Justice Stevens was there past 90, right, 4 years. God willing, Justice Ginsburg is 87, so there's a chance. She takes much better care of herself than most of her male colleagues, as far as I can tell, but that never gets mentioned. This seat, you tell me, from your point of view, what are the worst decisions of the Rehnquist and Roberts court, and how many were 5-4 with Justice Kennedy in the majority? That's one way of thinking about how important this seat is, right? Justice Kennedy is now remains in control, so forget about revisiting Citizens United, forget about Shelby County, forget about revisiting Heller and McDonald, although that wouldn't be on my list of priorities given how narrowly it's been interpreted. It's interesting to think why Kennedy flipped on affirmative action for the first time. Generally, he's very much a race conservative. If one justice has been repulsed by the behavior of the president-elect, I think it's Anthony Kennedy. And so that may help explain his move in Fisher, and you may see more of the pushback in the years ahead. He always emphasizes thoughtful, civil, civic, respectful discourse. But again, how long will he be there? I don't know. So I think it is significant in terms of changing the law, whether Scalia or someone like Scalia is there versus a Garland. I think it'll become obviously, right, a lot more important depending upon what other vacancies arise.
Well, I'm certainly not qualified to talk about the legal implications of this compared to the three of you, but let me maybe highlight one dimension that is more political in nature that I think actually is critical, and that would have been, right, for which all these seats are important and would have been important if Clinton had won too, which is the following, and it goes back to the issue of polarization. And before I say it, let me say one thing that's sort of on the other side, the glass half full, right? So even now, if you look over the last few terms, 35, 40, 45% of Supreme Court decisions are unanimous, right? That has to do obviously with the various functions that the court serves. But one thing is, if you look at the non-unanimous decisions of the Supreme Court, and I just did it the other day, one thing that political scientists like to do is to say, okay, suppose we try to estimate just an ideological model, a left-right model, to place judges, right, the justices on that left-right spectrum based on their votes, trying to predict how well that left-right placement does in predicting how they vote and how the coalitions fall out. And once you've done that, you can then ask yourself, right, I have my model that says, right, so we've got them all lined up from left to right. Now I can go back and say, let me actually look at all of the decisions and see how many of them fall out in a way in which the coalitions perfectly reflect the underlying ideological, right, sort of dimension that I've estimated here. In other words, how well does an ideological model predict how they actually vote? And one of the things that you will find is that proportion of cases has gone up fairly significantly over the last 10 years, right? So if you go back to about 2000, among the non-unanimous cases, it's about 35%. In the last term, it was 55%, right? So more and more of these cases break down in clear ideological lines, and we now are in a world in which all the Democratic appointees are on the left, all the Republican appointees are on the right. And if the Kennedy seat goes, we may very well be in a world in which we now get solid conservative blocs voting one way, and the court will be perceived increasingly to be a political partisan institution. That's not to say it hasn't been perceived that way on occasion in the past for specific decisions, but the fact that we may be entering a world in which it's going to look a whole lot more like a just straight up partisan institution to most people in the country, I think is a worrying thing for how people think about the law and the rule of law and what the Constitution actually means. And that's separate from how the actual, and so how the law develops.
Can I add one little coda to all that? And Neil's heard me kind of mention this before, but I happened to be at one of Justice Scalia's last public appearances before he died. He gave a speech in Philadelphia, and though Justice Scalia was prone to be melodramatic and perhaps overstate things, maybe just sort of pick up on Craig's point, Justice Scalia was at least manifesting at that point the attitude that he had lost much more than he'd won. That he was not thinking that he was on the winning side of the court at that moment in history. So he was feeling, and again, you take this with a gigantic grain of salt, but to the extent that it becomes any kind of reliable measure of what Scalia was thinking and what somebody else might be able to do in the absence of Scalia, it may be to go where he wasn't able to go, and to be able to do what he felt he was not able to do. And that may be something that obviously we got to keep on the radar screen.
Questions?
So, Professors, how do you see a new Supreme Court nominee would influence law school, either the education itself or like funding for public interest programs and law students ourselves, and how should we respond?
Most of it. Okay. So how do we see the next nominee in terms of law school and their public interest background? Would that be fair? And how should law students respond? Well, I think there are a couple things. I mean, one is what we've seen is there's been a tendency over time, and this tendency may not continue, to try and look for nominees that are don't have what we call the paper trail of a Robert Bork, who don't have a lot of opinions, speeches, and other things that are sort of lightning rods for them. So what's happened is you get more and more boring people, who they're boring in different ways. So that's one thing I can predict, is whoever the next nominee will be is likely to be very boring. Second thing I would predict is probably very quickly out of his or her mouth will be how much they respect Merrick Garland. Oh gosh, what a loss for the country you didn't get Merrick Garland on the Supreme Court. But I think more to your point about public interest and how law students should respond. I think that one of the things that has been in play for some time in Washington is an effort to try and penalize people for public interest work, particularly young lawyers. Make it harder for young lawyers to get involved with public work. Why? Because it's going to come back to haunt you. We've seen this with a number of nominees to executive posts where they're representing particular defendants, and then lo and behold, they come back as a nominee and they get shot down because they were just trying to do their job as advocates. That's not an accident. That was not a coincidence. That is a purposeful effort to suppress activity. So you have to push against that. That's one thing I would say. You have to have the courage of your convictions. You have to be willing to sort of take not just a long review, but do that step-by-step work you have to do wherever it takes you on the basis of your values and the things you care about. You can't let whatever the political consequences may be 20 years down the road dissuade you from doing what you think is the right thing to do. We need lawyers that do that. And so I think you're going to find that what I'm worried about in Washington is the extent to which there's a majority that's going to continue to penalize people who are not just expressing themselves, but trying to engage in a certain variety of activities on the basis of their beliefs, and that is inappropriate. That is, it's not fair to your generation, but I have to tell you, it's a challenge you face.
Yeah, so I think that I've got two questions.
That's one.
Okay. All right. Well, so a lot of this had to do with how the nomination process has become very partisan, and there's not this civility, and a lot of it seems to be pointed to how this incident with Merrick Garland is really precedent setting. But especially with things like Miguel Estrada underneath Bush and other incidents with the Clinton administration, I mean, it certainly seems like this has not been a one-sided coin. And I don't know, it doesn't seem like there's this cordiality on one side and just the Republicans slashing it. It seems like this is finally the end of the road, and that's just, what do you all think on that?
Absolutely, and that's my generation. I watched Miguel Estrada's hearings. Nobody else probably did, I don't think. Why would you? So they're probably not even on YouTube. Fine, so Miguel Estrada was a super talented, really conservative Latino candidate who was filibustered for the D.C. Circuit. Peter Keisler, a white guy, amazingly talented, super middle of the road. If there were a right-wing Merrick Garland, maybe that was Peter Keisler for the D.C. Circuit. He didn't get a hearing. So, at the hands of Democrats, Republicans, gnashing their teeth. We're going to get them. We ever get a chance, we're totally going to get them. And then you guys may know, because this is your generation, so Patty Millett is nominated to the D.C. Circuit. Terrific judge. Amazing judge. The kind of person whom you couldn't stop with a filibuster, and indeed, Republicans couldn't stop her with a filibuster. The filibuster for circuit judges goes away as a result of Judge Patty Millett. Okay? So this is the getting back and so forth. And so then, says Mitch McConnell, if he were here, we're showing you guys for all that stuff you did to us all those years ago and so on and so forth. While the Democrats quite rightly say no one's ever done anything like this to a Supreme Court justice. Never done anything like this to a Supreme Court justice. Both sides are right. At Patty Millett's confirmation hearing, I was there for that one. It was almost as if the Democrats and Republicans had swapped speeches. I had this really weird it was and they're almost making jokes about it. They're like, "Oh, Leahy, you're reading the speech that I gave last year. Ha ha. Well, let me borrow yours. I'm gonna read the speech you gave last year. The president should be able to confirm. The Senate should be able to stop." So yes, I think that that's all true. It's happening. It's a much larger framework that if we had a lot of time, we could talk a lot about. But now what is really the question? And Merrick Garland's treatment is, I assert again, the more you learn about it, it is different. And it is wrong. And the real question is, where do we go from here? And the fact that the Republicans did it this time and maybe the Democrats do it next time, to me, when I look at that, that's not a prisoner's dilemma that gets us back to civility. To me, that's a spiral I feel like I've been watching for 15 years. And I don't see how we're going to hit the bottom and then it's going to go better again. For me, I have the nightmares. And it's how much worse could it get? Oh, it could get worse. Could it get worse than that? Oh, it could get worse. And so that's my reaction. For me, it's not, but I think it's a very important point. Keisler, Estrada, and there are others, but those are two I think that Republicans are right to stress. Where were you guys when these folks were up? And the answer was, I was reading your speeches. That's the answer.
So I would certainly agree that the Democrats don't have clean hands, but I would reject any implication that there's simply both sides are equally to blame. I would reject a claim, right? We've seen a lot of false equivalency claims being made, and I would reject it because we have examples of Democratic Senates confirming Republican nominees. Right? We don't have examples for the Supreme Court, right? We don't have examples of Republican Senates confirming Democratic nominees, and I think this, with a year left, 25%. I mean, think about the argument. The argument made was that the American people should have a voice in determining this nomination. That's the argument. Now, there are so many things wrong with that argument, and the same people who made it were prepared to say, well, if we don't like how they speak, we're just going to hold it. We're going to continue to hold it open, right? But let's follow through the implications of that argument. If the American people should have a say in deciding which president makes the nomination, shouldn't the American people have a say in which Senate decides on the nomination? In which case, we should be holding this open until 2020, so that every senator elected in so this is the kind of argument they got behind. We've never seen anything like this. I thought Estrada should have been confirmed. I didn't know as much about Keisler at the time. When I was doing shows for NPR during the Alito hearings, and Ted Kennedy was going after Alito for ethical lapses, that I thought were complete and utter nonsense. I said as much on national radio, right? So yeah, both sides, right, don't have clean hands. But I mean, literally taking a seat on the court from one party to the other, I don't think that's anywhere in the same ballpark as denying a strata. Really, not because they're concerned that would then give him a perch to get to the Supreme Court as the first Latino, right? Yeah, I thought that was wrong. But I don't think we've seen plenty of that on the Republican side with the lower courts, and I don't think that's equivalent to what we've seen with respect to what we've seen here.
Let me just follow that up really fast. I think, of course, we should remember the past doesn't determine the future. People, all because something's happened in the past, doesn't force somebody to do something bad now. That's something that people have kind of jumped over. But after one of the nastiest elections in American history, John Adams had a lame duck appointment to the Chief Justice. He appointed John Marshall. You all know that. And Thomas Jefferson hated his guts. There's not a word from Thomas Jefferson that Adams shouldn't have done it. Not a single word. And trust me, it's not as if Jefferson liked him or respected him. So that gives you some sense of how we've traveled. It's going down. And I think that people have the ability to choose not to go down. And I think that's going to be the big challenge now, is to what extent will leaders and others make a choice, okay, we don't have to keep doing it the way it's been done. Can we be a better example? Sometimes you lose now because you're trying to set an example for later.
I have to run. This was fun, but they're waiting in another classroom.
Thank you, George. Thank you.
We are all out of time. We will all have to run now. Thank you very much for coming.